Kia ora mai tātou, tēnā tātou katoa. Members, when we broke for the dinner adjournment, we were debating the Substance Addiction Compulsory Assessment and Treatment Bill. David Clendon was speaking. He has 1 minute and 30 seconds remaining. Jacinda Ardern.
Speaker. Thank you, Mr Speaker. It's my pleasure to follow on from my colleague David Clendon from the Green Party, who really, when we left for the dinner break, was highlighting a number of issues that I really would concur with around the need for this modernisation of this legislation. I mean, we're talking about legislation around compulsory treatment that was initially drafted from memory in 1966. And as is the case with many bills in this legislation in this area, revision is necessary, and evidence and research tells us actually how we should be crafting in this day and age effective legislation. And in that regard, when you talk about compulsory assessment and treatment for substance addiction, of course, we are talking about a very small group of people who will ever make it that particular threshold. And it does sound like the extreme to act to compulsorily force someone into treatment. That does sound like, in 2016, quite an extreme act. But I do want to highlight that when you read the preliminary provisions, the purpose clause of this bill, it's very clear that the focus is on the patient, as it were, on the person who has that need. And so I wanted to highlight the purpose clause. Purpose is to enable persons to receive compulsory treatment if they have a severe substance addiction that's being estimated to be roughly 200 New Zealanders a year, and their capacity to make decisions about treatment for that addiction is severely impaired, so that compulsory treatment may A, protect them from harm, B, facilitate a comprehensive assessment of the addiction, C, stabilise their health through the application of medical treatment, D, protect and enhance their mana and dignity and restore their capacity to make informed decisions about further treatment and substance use, and E, facilitate planning for their treatment and care to be continued on a voluntary basis, and F, give them an opportunity to engage in voluntary treatment. So in first reading, when you read this bill, and it's 8 weeks that someone may be under an order under this bill, look, ultimately, in terms of long-term treatment programs, that might seem quite short in terms of being effective, but the aim of this bill, as set out in the purpose clause, is ultimately to restore them to a place where they can make voluntary decisions for themselves. And equally, what I want to point out, that of course this is a health-based approach to substance addiction. And ultimately, that is what we should be doing. If we're setting out the proviso here where we're saying this isn't about a criminal justice response, it's about a health-based response. That is a mantra we should be expanding across our legislation. It's what the Law Commission recommended we do. There's a small nudge to it here, and those purpose clauses capture it brilliantly for me. But we need to be doing that more and more across our drug laws in New Zealand, as the Law Commission has highlighted we should. It's something that Labor has tried to encourage this House to have a debate on and still absolutely believe in. But equally, canvassing this bill has highlighted another gap in our legislation, and that is the lack of service provision. Now, in this submissions, that issue was raised really concisely. That's been canvassed in this House. There's been an estimate that the 200 New Zealanders who might receive compulsory treatment, that's going to cost roughly $700,000, I would say probably at a minimum. Whenever we've seen times where the government has said, look, your priority now is to either treat, for instance, those compulsory treatment clients, or, for instance, when they highlighted that they wanted a particular number of meth beds, all that in the past has done is suck resource out of other parts of an already stretched system. So resourcing these beds is incredibly important. And having sat in the back of the Drug and Alcohol Court in recent times, and I cannot state enough how phenomenal that program is. Having sat in the back of that court, it was obvious the need for placement. You had people on before the court who had voluntarily put their hand up to be part of the drug and alcohol treatment program, who were in prison, waiting to be part of the program, but could not start because they could not find beds for them in rehabilitation programs. Those are people who are voluntarily saying, I'm ready to be a part of this, who have cost a huge amount to taxpayers through our system because of their addiction. We need to resource this properly, Mr. Speaker, so we support this bill, but it must be properly resourced, as does all of our addiction services, and we will ultimately save taxpayers a huge amount of money and harm by doing that very thing.
Kia ora.